The court, unless we've put down an order saying otherwise, the oral arguments will be streamed live and then will be later placed on the AOC's website, YouTube website, trying to make everything as available to the public as possible. Call the first case, please.
Yes, Your Honor. Gilbert, Heredia v. City of Knoxville et al.
We'll hear from the appellate.
Good afternoon. Herbert Buns here for the appellants. I would like to reserve 5 minutes of my argument, if I may.
That'll be fine.
With regarding the failure to prosecute, this might be the first case in the jurisprudence of Tennessee to where there were 148 docket entries on a case that was dismissed for failure to prosecute. And interestingly enough, we have, of course, former Judge Davis, who presided over this case for 5.5 years, and then Judge Milson, who took over the case. Judge Davis had, of course, analyzed the first two claims, failure to prosecute, and found that those were without merit, and during the period of time that she was administering the docket and overruled them. Judge Jerome Milson came on January the 12th of 2021, and after he came on board, there were 84 of those entries of activity before him. When he came on, and interestingly enough, when he came on, shortly after him coming on, I can't talk about what the practice was during that interim period because it's not the record. But he had a method by which he was working into the docket, and we were not able to get our motion set until September of 2022, at which time he chose to hear the motions to dismiss for failure to prosecute and motion res judicata instead of the motion for summary judgment that had been pending for several years and had been renewed. There is a complaint by my colleagues about the multiple amendments in this case. As this court may be aware, on September the 9th of 2015, our Tennessee Supreme Court decided the case of State versus Sprunger. And as of that date, activity, and I've been very much at the forefront of that activity, and the forfeiture litigation in the state of Tennessee has been extremely active. This case, as well as 3 other cases that were before Judge Davis, as well as the cases in Davidson County that were relied on for res judicata, were all cases in which I was pursuing to try to establish what various issues were after the Sprunger case. So in the failure to prosecute, as I understand the standard, is that a judge has wide discretion in maintaining their docket. That's the fundamental thing. But when you apply that standard to this case, former Judge Davis had the docket for 5.5 years. She was the one that knew what, if any, effect the delay in this case had on the docket. She was the one that knew all of the cases that she was dealing with and another circuit court was dealing with, and that she was hearing about through the parties that were occurring in Davidson County. So our position is her finding the fact that there was not a failure to prosecute, number one, and number two, that there was no prejudice to the Department of Safety. While it may not be binding, it is certainly tremendously high persuasive authority. Judge Milson, for whatever reasons he chose to do so, he ruled differently. No new evidence was before him. Matter of fact, the case was more active before him, and it's not because it was before him, it was more active because these appellate court cases that were all related one way or the other were getting decided by the appellate courts. The Morton case, for example, that we cite in our paper, where the Knox County was the defendant instead of the city of Knoxville, but the department was still the party that was claiming sovereign immunity to this statute 4033-215. Well, that's critical. If there was sovereign immunity that applied to that statute, then these other cases, including the Heredia and including the Groves case, there wasn't jurisdiction. And of course, former Judge Davis was the one that decided that case. She also decided that Rule 9 criteria was applicable, gave it to them, and the Tennessee Department of Safety took that up to the Court of Appeals and they lost. They took it to the Supreme Court. Well, all of that delay that was in there was critical for these cases to go forward. The failure to prosecute this case, I suggest, was clearly erroneous in light of the preponderance of the evidence that showed that there was an extraordinarily active prosecution. Contrary to the findings of Judge Davis, that these cases had all been intertwined and had caused, and the parties had caused delay. One last point on the failure to prosecute. While we might not have put down as much information as we should have when we were before Judge Davis, when we got before Judge Milson, he was a little bit more formal. And so my colleagues and I, as we were waiting on these other cases to be decided that impacted this case, my colleagues and I agreed to 5 agreed orders to reset motions. They weren't just on me. I mean, it just made sense to all of us. Now they come in and they use that time in which they agreed to written orders, resetting motion dates, waiting for opinions to get a dismissal. Judge Melson chose not to talk about those things. Judge Melson's went back under Judge Davis and said there was a 2-year period of time that there was inactivity. Well, of course there was. That was the period of time that everybody was waiting to find out whether the court had subject matter jurisdiction or not. If I could move forward very quickly into res judicata. I filed a supplemental authority this morning of the late Judge Susano's doctrine of Goodwin versus Metro that provides and has since been applied by the courts up until the present time, that you cannot join an administrative review proceeding in a judicial court with an original cause of action. Now, 2 things happen when you do that. 1, the original cause of action gets dismissed and it proceeds on the judicial administrative review, or 2, they get severed and they do not get decided at the same time because the standards and the matters that Judge Susano said. All of the litigation in Davidson County was localized. All of it was dealing with judicial review of administrative proceedings. It is true that in the first one, the big one that was filed, it was a class action suit. In that class action suit, and we presented the order in this record, in that class action suit there were various classes that would have had damages to that subclass, and they were broken down. One of them was a claim that if there would be a class action, they would have their claims under 4035-215 for damages, attorney fees, and a jury trial, handled separately from the judicial review issues. Chancellor Hobbs-Lyle chose to do in Goodson, address the judicial review as to whether there was standing for a class action case. And she ruled that as hard as we tried, and I did try hard, she ruled we didn't have standing. The people that I put forward did not have standing, did not touch the underlying claims, did not address them. The claim of 4033-215 was not mentioned in her opinion. So that was the first case that did not address it. Judge Melson, I have suggested and I argue homogenized or maybe pasteurized, I'm not sure which one, the action, administrative action that an administrative judge can provide for attorney fees under the statute 45325, which is an administrative statute, with the judicial original action provided for in 4035-215. Those statutes have completely different standards. I just would point out to you that Judge Melson at, I'm sorry, I can't even read what I typed. I hope I did. Judge Melson ruled at, I'll get the page number in my rebuttal, ruled that Rule 41.01 provides that if there is a judgment of failure to prosecute, that is on the merits. He was wrong. I couldn't get him off of it, but he was wrong. There was never a judgment on the merits under the Elvis criteria that would accomplish res judicata. I see my time's up.
You have your time for rebuttal.
Thank you, sir.
We'll hear from the appellees. Will there be more than one argument on the appellee side?
Yes, Your Honor. We'd like to reserve 2 minutes for the city of Knoxville.
Okay, 13 minutes and then 2 minutes, right?
Yes, sir.
That'll be fine.
May it please the court. My name is David Wickenheiser, and I represent the Tennessee Department of Safety and Homeland Security in this appeal. This case, at its core, is about the finality of litigation and the proper use of the legal system. Litigants are entitled to 2 things: the fair and timely resolution of disputes and enforceable judgments once those disputes have been resolved. The appellants in this case, Mr. Heredia and Mr. Groves, have received both of those things. They have had their day in court on multiple occasions, but rather than accept those results, they have prolonged this litigation for nearly a decade, revisiting the same claims, seeking the same relief. The trial court dismissed these cases on 2 independent and fully sufficient grounds. First, for a failure to prosecute, and second, because the claims are barred by res judicata. Because the trial court correctly decided these issues, this court should affirm. Let me begin with the failure to prosecute. This dismissal is reviewed under a deferential abuse of discretion standard. This review is subject to the presumption that the trial court's opinion below was correct. To prevail, appellants must show that the trial court applied the incorrect legal standard, reached an illogical or unreasonable decision, or based its decision on a clearly erroneous assessment of the evidence. Appellants have made no such showing. Tennessee Rule of Civil Procedure 41.02 empowers trial courts to dismiss actions when plaintiffs have failed to prosecute their case. And the trial court here made specific findings that permitting the case to proceed after nearly 8 years of litigation would unduly prejudice the department. In those 8 years, appellants have delayed, withdrew, and reshaped their claims. They have filed numerous motions that they never set for hearing. They have ignored discovery obligations, and they let the case languish for years at a time. I want to highlight a few key dates from the record. This case was filed in November 2015, almost 10 years ago. Just a month later, the department filed its first motion to dismiss. In response, appellants moved to amend their complaint, but did not actually file an amended complaint for 4 years. From 2016 to 2019, the record reflects that no filings were made by the appellants. That's a 3-year period of complete inactivity. The department issued discovery in 2020, but appellants did not respond. After months of waiting, the department was forced to file a motion to compel in March 2021. For nearly the rest of all of 2021, again, the case sat completely dormant. All told, appellants have filed 5 complaints over 8 years, each time restarting the clock on litigation and avoiding a ruling on the merits. They filed 2 summary judgment motions, but neither was heard. They failed to respond to discovery for 9 months. They left the case dormant for years at a time. The repeated amendments and shifting claims, the repeated amendments resulted in shifting claims and deleted allegations, all while maintaining the same simple dispute. Did the department act in bad faith by waiting more than 30 days to set appellant's civil asset forfeiture hearing? That's it. That's the question. There's no reason for the simple question to have dragged on for almost a decade. In the words of the trial court, this caused undue prejudice to the department, and rightly so. Witness memories fade, records become harder to locate, staff turnover accumulates, and courts cannot effectively manage their dockets under a decade-long litigation.
Well, tell me again, what was the undue prejudice?
Yes, Your Honor. So first, I first want to be clear here that the trial court did make a finding of undue prejudice, but the case law does not require such a finding. I think the trial court was really explaining its reason for ruling such a way, but there's no actual requirement. But there was certainly undue prejudice in this instance, and I think the prejudice at bottom is that the knowledge and expertise needed to defend a claim was lost over 10 years of litigation. Think about, and I think it's important to put it within the context of what specifically was alleged here. The appellants are arguing that the department acted in bad faith by making a specific legal strategic decision 10 years ago. So we need to be able to put forward our defense of why we made those decisions. And trying to think about 10 years ago, what was a specific legal strategy that you made in a single case becomes increasingly difficult as time goes on. 10 years ago, I was an engineer. I wasn't even a lawyer. And if you asked me to be deposed on why I made a specific calibration decision 10 years ago, I would really struggle to come up with an answer for that. And I think that's the prejudice that the department's encountering. And I think that putting that within the context of what Tennessee case law permits for failures to prosecute is really important. And I think the court's ruling fits comfortably within Tennessee's case law. In Hodges v. Attorney General, the Court of Appeals affirmed dismissal when a case languished for 11 months. In Geico v. GNS Transport, dismissal was upheld after 15 months of total inactivity. And in Barrera v. Bob Parks Realty, dismissal was upheld when a party failed to uphold its discovery obligations for just 2 months. Here we're dealing with years, not months of delay. Now, appellants argue because an earlier motion to dismiss for failure to prosecute was denied, the trial court is now foreclosed from granting a similar motion. But that argument lacks merit for 2 reasons. First, the record shows that the department's first motion to dismiss for failure to prosecute was based on a different premise. Then the department moved to dismiss for failure to prosecute because appellants hadn't filed their amended complaint in 4 years, so it hurt the department's ability to respond to a complaint that hadn't been filed. And so that is factually distinct in our argument here, which is that the pattern and systematic delay has created a cumulative prejudice over 10 years. So that question was never asked nor answered by the trial court below. And second, even if the motions were not factually distinct, under Tennessee Rules of Appellate Procedure 3A, the trial court is not bound by its prior interlocutory orders. It's permitted and even expected to revisit its old orders as the case develops and facts emerge. And indeed, appellants' view of what a prior order is and its preclusive effect would undermine the court's broad discretionary authority to control their dockets. The trial court correctly dismissed this case for failure to prosecute, and the judgment should be affirmed. Now, turning to res judicata, these claims are barred because they have already been litigated. The trial court's determination over this issue is reviewed de novo. The standard for claim preclusion is well settled. If the same parties or those in privity litigate or could have litigated the same cause of action in a court of competent jurisdiction, then they receive a final judgment on the merits, then those claims may not be refiled. Here we have 2 cases. Heredia 1, which was a class action in 2015 in Davidson County Chancery Court, where both appellants sought attorney's fees under the same statute relevant here, and that's 4033-215A. The Chancery Court dismissed that case on standing grounds, and this court affirmed. Second is Groves 1, which is an administrative proceeding in which an administrative law judge found that the department did not act in bad faith. Groves appealed part of that administrative law judge's order to Davidson Chancery, and the Chancery Court affirmed, specifically highlighting that Groves did not appeal the administrative law judge's denial of their request for attorney's fees. The claim here is the same, a demand for attorney's fees related to the seizure of property. So going through those elements of res judicata, first, the courts that heard the claims were courts of competent jurisdiction. Heredia 1 was decided by Davidson County Chancery Court, and I think there's no dispute here that that's a court of competent jurisdiction. Groves 1 was settled by an administrative law judge, and Tennessee law is clear that administrative decisions, when they resolve factual disputes and are acting in a judicial capacity, are entitled to a preclusive effect. That's exactly what happened here. The administrative law judge ruled that there is no bad faith, and the matter ended. And I think appellant supplemental authority is not on point here. I believe it would go to this element, but we're not arguing that on appeal in Davidson Chancery that is what created the preclusive effect. We are arguing that the preclusive effect was created at the administrative law judge level. So the supplemental authority I don't believe is on point. The second element, the parties were the same in both litigation. The department and the same appellants were in both cases. The claims and causes of action were also the same. Heredia 1 sought attorney's fees under the exact same statute present here, 4033-215A. Now, appellants argue that Groves 1 was brought under a different statute. They argue that was brought under Tennessee Code Annotated 45325, but the administrative law judge's order explicitly found that there was no bad faith, which is not an element of Tennessee Code Annotated 45325, but is an element of the statute relevant here, 4033-215A. I think that highlights that this issue was raised below and created a preclusive effect. Additionally, the cases were decided on the merits. Heredia 1 was dismissed for lack of standing, and Groves 1 was dismissed after briefing on the substance. Now, appellants argue that Heredia 1 involves standing, so that was not a judgment on the merits. But Tennessee Rules of Civil Procedure 41.02 does not list standing as one of the exceptions to the orders that creates a preclusive effect. And the Court of Appeals in Love versus Federal National Mortgage Association has already assessed whether or not a lack of standing in previous litigation prevents a preclusive effect, and has found that it does not. In short, appellants have pursued these claims again and again through administrative hearings, class actions, and judicial review. They have been denied, and they cannot keep litigating the same cases until they find a court that will agree with them. Our legal system requires both diligence and finality. These appellants have had ample opportunity, far more than most. They've had their case heard and dismissed by administrative judges, trial courts, and this court. And now, after nearly a decade of litigation, delay, and relitigation, it is time to bring this matter to a close. The department respectfully asks that you affirm the judgment of the trial court in full. Thank you.
Thank you. Hear from you, counsel.
Good afternoon. I'm Ronald Mills. I'm Deputy Law Director for the City of Knoxville, and am here representing the City of Knoxville. I don't really have a great deal to add here. The city agrees with the state that these actions were properly dismissed by the Circuit Court. I am certainly not here to argue the merits of the case as to whether the city is a seizing agency for the purpose of a claim for attorney's fees, particularly when the action that the case is primarily based on occurred well after the city turns over the handling of the matter to the state. That's not before the court. What I do want to point out, and I think it's appropriate to note, as the city did in its brief, that the very reason that the plaintiffs claim, and I will use the term plaintiffs rather than appellants because I think it's easier given the parties that we have here. The very reason the plaintiffs claim that these previous decisions that are cited by the state and relied on by the Circuit Court shouldn't apply to the city by res judicata is the same reason they allege in their amended complaints that they should apply to the city. They claim in their amended complaints that the city was in privity with the state in the proceedings that led to the dismissal of the forfeiture actions, that its interests were represented by the Department of Safety in these forfeiture proceedings, but opposing counsel in opposing dismissal of their claims for attorney's fees in the Circuit Court, and here they claim that it wasn't in privity with the state. So it's a matter of trying to plead both sides of the case, Your Honor. In the plaintiff's reply brief, it now appears that maybe they're trying to separate out some of these decisions that led to the circuit court's finding of res judicata and claim that the city wasn't a party to some of those decisions, but they still can't get past the fact that they pled in their amended complaints, number one, that the city was in privity with the state, number two, that there was a mutuality of interests, and number three, that the city's interests were represented by the department in the forfeiture proceedings, and number four, that it was the city was the beneficiary and the city was the real party in interest to all these forfeiture proceedings, because ultimately it comes down to the fact that city officers seized the vehicles and started the process of the forfeiture proceeding in the first place. But now, having pled this in the amended complaint, when it matters on appeal, the city's just a stranger to all of these proceedings. And I would submit to the court that you really just can't have it both ways. Rule 12.026 motions require that the court to assume the truth of the allegations of the complaint, even if they're inconvenient for the plaintiffs. And we're just asking this honorable court to do just that, to assume the truth of the allegations of the complaint for the purpose of dealing with the dismissal of these two cases before the circuit court and to affirm the decision of the circuit court.
Thank you. We'll hear from the appellant in rebuttal.
Referring to what my colleague, Mr. Mills, said last, the complaint, which never found its way into any of the litigation because we didn't get to it, alleges, and this has never been decided, issue of first impression, that the TDOS is nothing more than the agent of the locality that gets the benefit, gets the process, gets the proceeds, and that the TDOS simply prosecutes the case for them as its agent, to where the city of Knoxville is actually the principal and is sued as the principal because they get the benefit of the forfeiture. I did find the place with regard to Judge Melson. Judge Melson says at page 18, he cites Tennessee Rules of Civil Procedure 4102, providing that a court's dismissal for lack of prosecution operates as an adjudication on the merits. I have cited to you, while he had this case under advisement, the Britt decision out of the Western Section had been decided. I provided that Britt decision to him as well as my posted counsel. He chose not to address Britt. Britt says that a failure to prosecute does not establish on the merits for purposes of res judicata. Just right on point. Contrary to what he had put into his order, I couldn't turn it around, and that's the way it was. Addressing the Nashville cases as addressed by my colleague from the Attorney General's office. One, there's a case called Elvis versus somebody or other that has 4 criteria for res judicata to apply. One, that it was by a court of competent jurisdiction. Indeed, in the Groves case, there was an administrative judge who returned the property, but then sua sponte, without any arguments or without any pleadings or anything put in there, that attorney fees are denied because they didn't act in bad faith. Bad faith is not a criteria under 45325 administrative attorney fees. It is under the judicial original action 4033215. 43215 has a very specific definition of the term bad faith that's not in the administrative. Former Judge Davis held that the criteria in 4035215 is a jury question under the specific criteria done. Now, applying that case that they rely on under the Elvis factors, That administrative judge it was not a competent court to make a decision about a judicial original cause of action. The jurisdiction of that administrative judge was limited solely to 45325, which is a completely different statute than the 4035-215. So it doesn't meet the first criteria as being a court of competent jurisdiction. Secondly, the only case that was filed prior to this case was the class action case. And as I've already explained, the class action case, if the class action was divided into subsections of classes of different individuals that would have to establish their damages separate from another one of the class, all of this coming under the purview of State versus Sprunger. This had all been filed within 6 months of State versus Sprunger. The chancellor decided that they didn't have standing to bring a class action case. But the important thing is, going back to Judge Susano's Metro Goodwin, is that the chancellor could not, if we got down to the merits of the individual claims within the classes, could not adjudicate a claim under one of the classes for violations 45325, just attorney fees, with a separate class under 4033-215 for damages and a jury trial. Those two could not be adjudicated at the same time under the law of the state of Tennessee. Therefore, the chancellor never considered the 4035-215, didn't cite it, didn't address it, didn't do anything. The importance of that is that res judicata cannot apply to something that could not have been brought at the same time as the cause of action that would be before. What was before the Chancery Court was judicial review of administrative actions. You cannot join a judicial review of administrative action with an original action under 4035-215, and there's a reason for that.
Mr. Bonser, you've used your time.
I can't give you my reasons quick.
Real quick.
Thank you, Judge. The reason is that 4035-215 picks up with attorney fees after the administrative hearing and through the prosecution. It includes damages, an original cause of action damages that the administrative judge has no authority for, and it includes a jury trial. It is a completely separate cause of action that was not addressed in any case out of Davidson County or case cited by my opponents in this case or cited by Judge Melson. We ask that this court reverse this matter. We ask that we go back to Judge Melson, who, by the way, has pending the other cases are still in his court that are the same age as this case. And we ask that you say that we are entitled, if we prevail ultimately in this case, for attorney fees that were expended in handling this appeal. Thank you.
Court's thanks to all counsel. We appreciate your arguments today and your briefs on this matter.
Good day.
Good day. Have a good rest of today.